Good news and bad news. The bad news is each side gets up to 2 hours to talk to you all. The good news is I don't plan on taking 2 hours to convey, from our perspective, what should be conveyed to you all. Now, we're blessed here in Gwinnett County. Ms. Ham, Mr. Brown, excellent, fine prosecutors. Should be very proud to have them working in the district attorney's office. They do a great job. Judge Duncan does a great job every time I'm before her. She is sort of the referee in this case. We rise, if you want to know why the lawyers rise, when you all come in the courtroom, it's a sign of respect. Because you all are the actual judges in this case. You are the judges of the facts as you find them to be. After I sit down and Ms. Nizam gets to come back up and make a concluding argument, Judge Duncan will tell you what the law is, define legal terms for you, and it's called jury instructions, jury charge. And then after the judge tells you what the law is, you'll disappear back through that door and you will get a chance to deliberate and return a verdict that, in your opinion, speaks the truth in this case. It doesn't matter. It's a hard thing for a lawyer to say, but it doesn't matter what the lawyers think. It doesn't matter what the lawyers believe. What matters is the evidence in this case. And what matters is what you all ultimately believe and ultimately decide. Now, as I told you in opening a couple of days ago, I'm not a moron. I'm not an idiot. I get the heartstrings of this case. I've got 3 kids at home. My late dad was a New York police detective for 30 years. So I get it. It's tough. It is awful that all of us had to meet under these circumstances. It's a tragedy. Can't shirk it, can't put it aside. It's awful. But one of the charges that Judge Duncan is going to tell you is sympathy has no place in your verdict. All of you are sitting in those comfortable chairs rather than out there on the benches because you all told us in jury selection that you were impartial. You heard it over and over again. Were you leaning towards one side versus the other, or were you right down the middle? All of you said you were right down the middle. That's why you're sitting there now. And so when you go back to deliberate, and it's an awful case. It's a horrible case. It's not a shoplifting, it's not drugs, it's not DUI. I get that. But you're to base your verdict on the evidence, or the lack thereof, not on emotion. And so, Ms. Nizam, in her first closing argument, she used the phrase, and she's an excellent lawyer, I'm not knocking her. She used the phrase, little Amari. Amari's broken little body. Those are all emotional terms. Those all tug at the heartstrings. And the case itself tugs at your heartstrings. I get that. But at the end of the day, ladies and gentlemen, after I sit down, Ms. Nizam sits down, Judge Duncan tells you what the law is, you are to base your verdict in all these counts not on the heartstrings, not on emotion, not on sympathy. You are to base your verdict on the evidence or the lack thereof. Plain and simple. No matter what phrases you hear, no matter the images that are posed to you, whatever words are used, that's what you're to base your verdict on. The evidence or the lack thereof. So start off with this concept. There is no direct evidence, and there's 2 types of evidence, direct evidence and circumstantial evidence. So let's talk about what's direct evidence. Direct evidence is a witness comes in, says, I saw Celeste kill Amari. Saw her hands around her neck, saw her take a hammer and hit her. That would have been direct evidence. Somebody actually saw it. You don't have that in this case. Yeah, you saw the videos up on the screen of what was going on in the Congress Hotel. That was in July of 2021. That was not November of 2021. You saw no videos from the room at Hometown from November. So those videos that were played with Ms. Hall in some and Ms. Owens purportedly in the other were from July of 2021. So first off, in regards to malice murder, felony murder, the other 2 counts of felony murder, ag assault, ag battery, and you'll have the indictment out with you. There's no direct evidence that Ms. Owens, and you may hear her referred to as a defendant, well, she's Celeste Owens. There's no direct evidence she killed Amari. That's the starting point. Obviously, they're sitting at that table, representing the state of Georgia, prosecuting the case, so that's their view of the evidence. But the evidence in and of itself, there is no direct evidence that she killed Amari. So you get to circumstantial evidence. And Ms. Nazan gave a very good description of what is circumstantial evidence. You go to bed, you're in your bed at night, and you hear droplets coming down on the roof, lightning, thunder. You believe it's raining. You wake up in the morning, go outside, the sun is out, the pavement is dry, the grass somewhat wet. Well, circumstantial evidence, it might be that it was raining the night before. But pavement being dry, it could also be asserted that that's morning dew. The sun is out, there's no puddles on the ground, yet the grass is somewhat wet. That is circumstantial evidence, because you didn't actually see what caused the ground to be wet after the sun came up the next morning. So that's the 2 types of evidence: direct evidence or circumstantial evidence. There's no direct evidence she killed Amari. I would submit to you all there's also no circumstantial evidence that Celeste Owens killed Amari. Now, you got the videos, you got the photos, but that doesn't prove what took place in November. Now, I'm also not an idiot and not a moron standing up here before you all. I'm not telling you you have to like Celeste Owens. I'm not telling you you have to appreciate her, respect her, like her. I'm not telling you that at all. But this case is not about who you like, who you don't like, who you respect, or who you don't respect. This case is about the evidence. When the state brings these charges, I don't care if it's 1, 2, or 22, they do have the burden of proof by evidence, beyond a reasonable doubt, that the person or persons, and in this case they've charged 2 people, Mom, Brittany, and I'm glad to hear she'll have her day in court probably sometime in the new year, and my client, Ms. Owens. She's the one who's been on trial this week. So the state has the burden of proving to you all, beyond a reasonable doubt, that she is guilty of these crimes. Not that she's a bad person. Not that you should hate her, dislike her. The burden of proof, this is a criminal case, the burden of proof is by evidence to convince you all that she's guilty of all of these charges, by direct or circumstantial evidence. They further, when you have the indictment out with you, you will see in each count, other than count 21, in each count, and I think count 20 deals with Brittany lying to the police, saying her daughter went missing. So counts 1 through 19, you will have, and you'll see the way it's indicted. And indicted just means charge. Fancy legal word for charge. You'll see that they're indicted individually as well as parties to the crime. What does that mean? That means the state is trying to have it both ways in the indictment. You'll actually see those words in the indictment, individually and as parties. The way it says, just to give you an example, in regards to count 1, it says, grand jurors charge and accuse Brittany Nicole Hall and Celeste Alexandria Owens individually and as parties concerned in the commission of a crime with the offense of malice murder. And it goes on that way for the next 18 counts. Individually, that they each individually killed Amari, and or parties together, working together by assisting each other, helping each other committing these crimes. Well, which is it? Doesn't matter in regards to the evidence, because the evidence, whether direct is not there and whether circumstantial is not there. Not only that Celeste did not individually kill Amari with malice or without, but the evidence is simply not there that she assisted, helped, participated with Brittany in killing Amari. That's a tragedy. It absolutely is a tragedy. We should not be here, but we are. And since we are, when you go back out there after listening to Ms. Nizam's, I'm sure it'll be a great closing, and the instructions from Judge Duncan, when you go back out there to deliberate, this is not whether she's a good person, whether she's a nice person. This is whether or not the state, by evidence, has proven her guilt, either as individual or as a party to the crime in killing Amari. A party to a crime, in basic terms, means doing something, helping, assisting, participating. And in going over all the evidence, the videos, I just heard Ms. Nizam say something about 2 voices on those videos. It's not a crime to talk. It's not a crime to speak. Party to the crime means doing something to help the person commit the crime. Classic example is the liquor store robbery, where one person's the driver. They drive up to the liquor store, the gunman gets out of the car, goes into the liquor store, holds it up, gets the cash, comes back out, gets back in the car, and the getaway driver drives them both away. That's a party to a crime. The getaway driver, aware of what his co-defendant, armed robber, is doing, is the getaway driver. That's a party to the crime. Ask yourselves, in regards to the evidence in this case, what specifically did Celeste Owens do to help, assist, participate with Brittany Hall in killing Amari? What did she do? We don't even know, evidence-wise, ladies and gentlemen, the day Amari died. More importantly, we don't even know, evidence-wise, I don't care what lawyers say, evidence-wise, where Amari died. You don't even have any evidence of that in this case. So they want to say that Celeste, individually or as a party to the crime with Brittany, killed Amari, helped Brittany, assisted Brittany in killing Amari. Let's start off with, where was she killed? We don't know. We have no evidence of that whatsoever. And so from an evidence standpoint, I submit to you all, there is no evidence, not opinion, not talk, but evidence of what Celeste Owens actually did to help, assist, participate in Amari's death, Amari's killing. You don't have that. State has their theory, of course, and that's why we're here with these charges. But bringing charges does not mean somebody is guilty. The videos from July, yeah, horrific, absolutely. But it's not evidence of what took place purportedly in November. It's not evidence that Celeste Owens knowingly assisted or participated in November in killing Amari. But they're hanging their hat, they're banking on what took place via video in July. It was Brittany who was Amari's primary caregiver. It's not a co-parenting relationship. We heard that from grandmother, Ms. Wright, that she and Brittany would co-parent all 3 children. And in that house, in that motel room, when the police showed up, who was giving the majority of the info, height, weight, autism, medications, to the police about Amari? It was not Ms. Owens, it was Brittany Hall, the mom. So she was the primary caregiver for Amari. I submit to you all that fact is uncontroverted. You heard from Zaire. God bless her. 9, 10 years of age, having to come into a courtroom in front of a group of strangers. Thankfully, she had a good rapport with Mr. Brown, with Brian, and thankfully he told her that a nice man was going to be asking her some questions after he sat down. And I appreciate him telling her that. And I submit to you, she's a child doing the best she could. What's important, though, that I ask you to remember is Zaire. She didn't remember her mom's name. Okay. And she's up there doing the best she can. But she told you all, Mommy never hit me. Brittany never hit her. That's just not true. Ms. Wright, God bless her grandma, she was unaware that her daughter was using corporal punishment, hitting, smacking, kicking, stomping on her own children, Ms. Wright's grandchildren. But it's just not credible, not believable for Zaire to tell you all that Mommy never hit her, because that's not true. She also testified, and remember Judge Duncan swearing every witness in to tell the truth. I'm not knocking Zaire, but these are factors that you all have to take into consideration in deciding this case. Zaire testified she never slept in a bed. May seem like an innocuous response to something, but it's important. Why? Because for almost 3 months, from September through November of 2021, they slept in that second bed, in that room there at the hometown suites. When police came in that motel room to talk to Brittany and Celeste, what did they say? 2 other kids, who would include Zaire, were asleep in the bed. That's important because Zaire told you all she never slept in a bed. That's just not true. She told the police when Mr. Brown sat down and I got to ask her some questions, she had seen her interview and it refreshed her recollection when she talked to police 3 years ago. And I asked her, you remember telling the police that it was a man who took Amari by the neck and put her in a dark room? She said yes. She remembered that because that's what she told the police, that a man took her sister by the neck and put her in a dark room. She said also to the police, Amari had toilet paper in her mouth, and the next morning she wouldn't wake up. That's what she remembered from November of 2021. But none of that, ladies and gentlemen, from an evidence standpoint, shows Celeste Owens killing, murdering, with malice or without Amari. None of that does. Ms. Wright was unaware of Amari's autism and was unaware of her medications. And I applaud Ms. Wright for being a great grandmother. I mean, she took care of these kids as Brittany came in and out of her life. Would have one child, go back to the nest, leave, have another child, go back to the nest, leave, and have another child. And God bless Ms. Wright for stepping into the breach, time and time again, in an incredibly painful situation. But none of that shines any evidence on Celeste Owens being a killer. I'm going to leave the cruelty to children counts. If you can square away and figure out the tattoos on the legs, no tattoos on the legs, who's doing what to whom back in July of 2021, I will leave that up to you all to decide from an evidence standpoint. But in regards to counts 1 through 8, the murder, malice murder, felony murder, ag battery for the lacerated liver, aggravated assault on Amari with an unknown object, please ask yourselves, no matter what I say, no matter what Ms. Nizam says, evidence-wise, where is the evidence to prove beyond a reasonable doubt that Celeste Owens did those things? It is not there. You'll have the verdict form out with you. That will go out with items of evidence. The verdict form lists all the counts. And you are to make an independent decision as to each count. Whatever your verdict is, you take count 1, count 2, count 3, and so forth. And let me go over, ladies and gentlemen, a little bit about what I expect Judge Duncan to tell you is the law in this case. Judge Duncan, I expect, will tell you that the defendant, Celeste Owens, is presumed innocent. So when we started the trial, it really wasn't leaning this way, it was leaning this way. Because Judge Duncan will tell you that the presumption of innocence surrounds and protects Celeste, and that presumption remains with her, innocence, until it is overcome by the state with, not opinion, you'll hear the word with evidence that is sufficient to convince you all beyond a reasonable doubt that she is guilty, and that the state has the burden of proving each and every element of each crime charged beyond a reasonable doubt. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. That's what a reasonable doubt is. Judge Duncan will tell you that the burden of proof rests upon the state to prove it beyond a reasonable doubt. She will tell you there is no burden whatsoever on us. We don't have to do anything. I could have sat here all trial, not asked one question, not done anything. Didn't have to make an opening statement, didn't have to make a closing statement, because there is no burden whatsoever on the defense to do anything. Still America, 2024, we don't have to do anything. But I did ask questions. Judge Duncan will also tell you that if the state, the prosecution, fails to prove Celeste Owens' guilt beyond a reasonable doubt, it would be your, and this is a key word you will hear when the judge tells you what the jury instructions are, it would be your duty to acquit her, find her not guilty, if they fail to prove her guilt beyond a reasonable doubt. You will hear that grave suspicion, mere conjecture, suspicion, maybe, could be, possibly, she's guilty, are not sufficient, aren't enough to find her guilty. Suspicion, conjecture, is not what the law requires. Yeah, the law doesn't require 100% mathematical certainty. That's absolutely correct. But the law does require proof beyond a reasonable doubt. And suspicion and conjecture, speculation, are not sufficient for you all to find her guilty. Judge Duncan will tell you that Celeste was under no duty, under no burden to testify. She didn't have to get up here and say anything. Because just like I didn't have to do anything, or say anything, or ask any questions, there is no burden on Celeste whatsoever to have to testify. And that you cannot, when you go back and deliberate and go over the evidence and the judge's instructions that you hear from her, you cannot use that in your deliberations, the fact that Celeste Owens did not choose to testify. Cannot at all base your verdict upon that. Judge Duncan, ladies and gentlemen, will define for you what parties to a crime is, because when you have the indictment and you look at it, you will see it says individually and as parties to the various allegations. And a party to a crime is a person is a party to a crime only if, and you will hear Judge Duncan tell you that, only if that person, in this case Celeste Owens, only if she directly commits the crime or intentionally helps in the commission of the crime. That's it. To be a party to a crime, you either do it directly or you help someone, participate with that person intentionally in committing the crime. You don't have that in this case, ladies and gentlemen. There is no evidence for either of those, that she directly killed Amari or intentionally helped Brittany kill Amari. Knowledge is an important aspect of party to a crime. And the judge will tell you, if you find from the evidence that the defendant, again, Celeste Owens, did not knowingly and intentionally commit, participate, or help in the commission of the alleged offense or offenses. You're going to hear those words again, those two words. It would be your duty to acquit the defendant, Celeste Owens. Find her not guilty. Judge Duncan will define for you what mere association is. It's the old adage, who you hang around with. If you're hanging around with the kids, I was always told, if you hang around with the kids from the other side of the tracks, you're going to get in trouble. So don't hang out with them. But mere association is not sufficient. Who you hang out with, who you choose to be your girlfriend your partner, spouse. That's not sufficient. Judge will tell you a jury is not authorized, you all, to find a person who was merely associated with other persons, Brittany, involved in the commission of a crime, guilty. Just who you choose to hang out with, just who you choose to be with, just who you choose to be in love with, associate with, is not enough. They, again, have to show you did something or helped in doing something in order to be guilty beyond a reasonable doubt. Malice murder, count 1, essentially with malice aforethought, those legal words that Ms. Nazan was talking about. Malice, bottom line, is the unlawful intention to kill. You unlawfully intended to kill Amari. That's what count 1 must be proven by the state by evidence beyond a reasonable doubt. It is not fair that she unlawfully intended to kill Amari. The murder counts, the felony murder counts. You have ag battery, ag assault, cruelty to children, all dealing with November. Not talking about July here, we're talking about November. And the state, beyond a reasonable doubt, must prove that Celeste caused the death of another person, Amari, by committing a felony, either ag battery or ag assault or cruelty to children. Again, they don't have to show malice, but what they do have to show is this person sitting over there who's been sitting next to me for 5 days, by evidence, killed Amari during a felony, or participated or assisted in Brittany killing Amari during the commission of a felony, by evidence. And ladies and gentlemen, they have not. And lastly, as I started off early on in my closing, ladies and gentlemen, Judge Duncan will tell you that your verdict should be a true verdict based upon your opinion of the, it's not going to say opening or closing statements of the lawyers. It's not going to say which lawyer or lawyers you liked or didn't like. Your verdict should be a true verdict based upon your opinion of the evidence, according to the laws given you in this charge. Judge Duncan will further tell you, you are not to show favor or sympathy to one party or the other. Brutally tough in a case like this, where you have an 8-year-old who's gone, who'll never see another birthday, or Christmas, or graduation, or grow up. Yeah, it's brutal. Absolutely it's brutal. But when you swore your oath, that's what you swore to do. You are not to show favor or sympathy to one party or the other. Judge Duncan will tell you it is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. Extremely tough and brutal in a case like this. But that's why you all were chosen, because that's what you swore an oath to do, and Judge Duncan will tell you that. She'll lastly tell you, ladies and gentlemen, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, economic status, for or against either party. Quite simply, you take people as you find them. You take the evidence as you find them. You take the law as given to you by Judge Duncan, that she will tell you after we sit down. I don't get to come back up here and counter or refute anything that Ms. Nazan or Mr. Brown, either one of them, comes back here and says in closing. Now, sitting over there, I may go, oh, I should have covered that. Why didn't I cover that? But at the end of the day, the bottom line, ladies and gentlemen, is the state has the full, total, and complete burden of proof beyond a reasonable doubt to prove to you by evidence that Celeste Owens is guilty. And I submit to you, in regards to the particular case before you all, the evidence that's been presented, that's not been presented, you never heard squat, jack about the crime level. So none of those pillowcases, clothing, none of that stuff was ever sent off. Or if it was, never got any results from it. Because if there had been blood in any of that stuff, I submit to you, you would have heard about it. But you don't have any of that before. So what you have in this case, ladies and gentlemen, is supposition, is guesswork, is, well, this is from July, Let's equate it now over to November. Guilty. I submit to you, ladies and gentlemen, please hold the state to their burden of proof, as the judge will tell you you must do. Render a verdict that speaks the truth in this case, based upon the evidence and the lack thereof. Follow the judge's instructions regarding your duty, and ask you to return a verdict of not guilty. Thank you.
Thank you, Mr. Greenwald. All right, ladies and gentlemen of the jury, I want everybody to stand up and stretch for a moment. Everybody good? You be seated when you're ready.
To believe that this defendant did not directly commit, help, or participate in the death of Amari Hall is to believe that essentially the defendant was tasked with caring for these children, being called their dad, being in a relationship with Brittany Owens, admitting in her interview with the police to living at the Congress Hotel, living at the Hometown Studios, to say that she had been in a relationship and had been getting to know the truth of being with the kids for going on 2 years, and that while all this is happening, she's just standing there watching. Just standing there, not doing anything other than watching Brittany Hall beat Amari. That's what she wants you to believe, and that's simply unbelievable. And the evidence is clear as to why that's unbelievable. And let's look at it now. So let's look at these videos. You see them, and it's hard to unsee them. But they saw it every day. She saw it every day. And the reason these videos are important, Detective Sorensen, said that they occurred over a range between July 20th and August 9th of 2021. That's when they were stamped. And the judge will also tell you that the date really doesn't matter, as long as it happens before the filing of the indictment. So we can pick a date, which was the first day, July 20th of 2021, but those videos occurred over a period of time. Detective Sorensen told you that, and the judges will also tell you that that date is not going to be an issue. But it is important. And here's why. It's important because Dr. Downs said that this was a pattern of abuse that had occurred starting from anywhere between days to months, various stages of healing, all of these different injuries on Amari. So what happened at the Congress Hotel does matter. It matters a lot. And this defendant directly was abusing not just Amari, but all of the children. Call it luck that the detective found those videos, call it divine intervention. I don't know what it was, but we do know that it happened. Ms. Penix came in here to tell you that the Congress Hotel, that's located here in Gwinnett County, because we have to prove to you that it occurred here in Gwinnett. So that's why she came in here and to tell you that. And so these videos and the individuals on the videos, Sergeant Campbell, the reason he came in here and gave a big pamphlet of all the different tattoos that are found on both defendants is so you can decipher who is who on these videos and who is doing what to whom. Now remember, all the evidence that came in, you will have that with you. You will be able to take that back, the photographs, the charts, all the different things. You'll be able to look at that yourself. This is Celeste Owens. This tattoo, I submit to you, you will see several times on the videos. You will see her face on several of these videos. You will hear her voice, which you spent almost 2 hours listening to when she spoke to Detective Sorensen. And you'll know that she has no tattoos on her legs. So we know when there's a tattoo on the leg, that it's going to be Brittany Hall. That's what Sergeant Campbell's purpose in coming to court to talk to you guys was about. And each of the counts in the bill of indictment, as they pertain to the cruelty to children charge, deal with the fact that we have to prove that this defendant, either individually, on her own, or as a party to a crime, either helping or being part of, remember, two people can commit the same crime, depending on the role that they play. Being there, having the same pattern of abuse, doing the same types of things, and being seen on video doing it, whether it was in July, August, or November, doesn't matter. Causing cruel and excessive physical and mental pain. So let's go straight to the point of what these videos are about. How humiliating.
Like this shit, you joy, bitch. What is it? Hey, and all in front of the store. So as you walk out,
To call an 8-year-old that, that's just sheer humiliation, right? Mental pain, excessive mental pain. Count 8 charges both defendants, but again, we're here for her today, for slapping Amari, causing her head to whip back while sitting on the ground. Here's count 8. Guilty. Count 9. Kicking and striking Jakari while he's blindfolded and laying on the ground. That's the language in each of these counts which you'll get to take back with you. We have to prove that beyond a reasonable doubt.
Don't move.
The tattoo on the arm. The voice. This defendant. Blindfolded children laying on the ground covered in blankets. This is not discipline. This is torture. This is humiliation. This is savage. Count 10. Stomping on Jakari while he's laying on the ground and telling him to go to the bathroom. Again, the language we have to prove beyond a reasonable doubt in count 10 of the indictment.
Let's go to the bathroom.
Guilty. And as an aside, remember Dr. Downs talking about Amari's lacerated liver? And how it could be caused by blunt force, flat surface like a foot, hitting the floor, getting squeezed between the two? Count 11, kicking and stomping on Jakari while telling him to move over. No tattoos on those legs. The language of count 11.
Move over. Put your arm down. Put it down.
Guilty. Again, same manner in which Dr. Downs testified Amari's injuries could have occurred. Count 12, striking Jakari repeatedly while he's sitting on the floor wrapped in a sheet. Again, look at Zaire. Blindfolded, staring at the wall with a sheet wrapped around her. She is 6 years old.
I know it's on 15. Huh? He finna get smacked. First of all, he finna get smacked now. I don't know if he's looking at me. Say, I'm finna handle it. Stop looking. Do you understand me? Keep your eyes to yourself. Do you understand? Stop looking. Stop looking. I smacked earlier for that.
Guilty. Count 12. Count 13. There's that koi fish tattoo again. This defendant striking Jakari and stomping on him, just like Amari's lacerated liver, while laying on the ground, shirtless and blindfolded, telling him to go to sleep. Another stone. Just like what Dr. Downs said, likely caused a lacerated liver. Count 14, repeatedly striking Jakari on the floor on the back while he's laying on the floor. Again, you don't see these kids sleeping on the bed much, do you? Guilty. Doesn't matter who's doing the slapping. They are parties to the crime, helping together, same manner. Count 15, repeatedly stomping on Jakari while he's laying on his stomach on the floor. Again.
floor right now. Yes, ma'am. Stop moving. Hold on.
Guilty. Doesn't matter who's doing the slumping. Count 17, striking Zaire with an unknown object while she's laying on the floor. I do want you to pay close attention to the second voice.
You still, you heard me? I'm sitting right here. You got this. I'm sitting right there.
He gets the point.
Talk about helping. You got this. I'm standing right here. Does that voice sound familiar? Guilty. Count 18. Stomping and kicking Zaire while she's on the floor and telling her to move the other way.
Turn the other way.
Guilty. Count 18. Why? Why would they? Why would they? That's why. She didn't need the sheet. She didn't cover up Jakari. She just didn't want Zaire to have her. And why this?
Fuck your fool. Turn around, put your hands up. I said swallow the food first, then take another bite because she dropped the mashed potatoes everywhere and tried to scoop it out the carpet with a spoon. Then I said stop. She stopped and finally trying to keep going after I said stop. So I slapped her super bad. Oh. Tomato busted in my mouth and I almost got on my picture.
You can see her face there in the corner. You can hear her voice. Who else is she talking to? There's only two people, two adults who lived in that room. Helping, encouraging, directly participating. Turn around and put your hands up? Stare at the wall? She's 6 years old. Guilty of every single count of cruelty to children in this indictment that this defendant is charged with. So let's move on to what really matters. It all matters because it's all connected. It's all intertwined. The first count in count 2 of felony murder has what we call an underlying count of cruelty to children. The felony in the felony murder in count 2 is cruelty to children. For causing Amari, who is under 18, cruel and excessive physical and mental pain by causing multiple blunt force injuries to Amari. 11 pages of injuries. Leaving her body. Various stages of healing. Various different places on the body. Those 15 videos show us that they act together. They encourage each other. They help each other. They hurt these children in the same way. They blindfold these children in the same way. Causing a cruel, excessive physical and mental pain. And to believe that she just stood there and didn't do a damn thing is unbelievable. They're acting together. Amari is in the care of this defendant. She tells Detective Sorensen, yeah, we're there all the time, we're homebodies. The hours leading up to Amari, we know from Investigator Wilbanks that this defendant was in the hometown studios. We know that the only time she left, and we contend that this happened on November 19th, because that's why the U-Haul was rented on November 19th. That's why she drove to the area where Amari was dumped. That's why we know it happened on November 19th. How long could she keep a dead child at the hometown studios? By causing blunt force injuries to Amari, by committing the offense of cruelty to children, she is guilty of felony murder in count 2. She is guilty for causing the death of Amari through committing the act of cruelty to children. Guilty to count 2. Felony murder in count 3 deals with a charge called aggravated battery. There's a lot of charges because a lot of things happen to this little girl. And she commits the offense, and this is the language that you'll find that we have to prove to you. The she commits the offense of aggravated battery by maliciously causing bodily harm to Amari Hall by rendering a member of her body useless, specifically her liver. Now, useless is sort of a legal term. Obviously, when you sever or when you actually lacerate the liver, as Dr. Downs testified, it's no longer usable. In this case, it caused her death. It was one of the things that ultimately caused her death, not the only thing. In other words, the defendant's actions caused Amari to have a lacerated liver, which then ultimately, in relation to all the other things, caused her death. The stomping that you saw in the video, that likely caused it. That is the state's theory, based on what Dr. Downs had said. But again, put together with all the other injuries on that little girl, because that's what she was, a little girl. And it doesn't matter who inflicted it, because her actions, as you saw, helped cause the injury. And if you believe that she could have stopped on that child, hit that child, if you believe she could have lifted her hand to strike that child, based on everything that you now know, that she is a party to the crime, and she is guilty of felony murder by committing the offense of aggravated battery, that she helped, either directly or helped or encouraged that liver to be lacerated. She's guilty. She can be guilty of every single count. Remember, you don't have to pick and choose. Count 4, felony murder for aggravated assault. Aggravated assault is when you assault another person with an object, device, or instrument which you can use offensively against another person, and that it actually does cause injury or could cause injury. And again, lots of legal words for basically saying if you use something that could kill or seriously injure someone else, that is what's called an offensive instrument, an offensive object. And here in the indictment, the state alleges that we don't know exactly what it was. We don't know if it was a foot, we don't know if it was a hand, we don't know if it was a belt, we don't know what it was, because they were beating these children with hands, feet, some sort of whip type thing. And so we don't have to be able to show you exactly what that was. We can say that that object can be unknown, but it is likely that it was the hands and feet of this defendant and Brittany Hall, because they're both charged, but together, that caused these injuries to her. I apologize, there is a typo here, but when deciding whether or not something is offensive in some way, you can look at various different things. But essentially, if you find that this defendant utilized some sort of an object, whether it be hands or feet, that ultimately resulted in the injuries to Amari, that's aggravated assault, either directly by helping or causing it to happen, then she is guilty of felony murder for the underlying offense of aggravated assault. Essentially, she is guilty of all the murders charged in the indictment. It is one death committed in multiple ways. And that's why there are numerous charges dealing with murder. And you can find her guilty of each of those ways of committing murder, because as Dr. Downs said, there's a lot of things that were done to Amari that caused her death, that she either helped with, encouraged, or directly participated in. So what happened to Amari on November 19, 2021? She certainly didn't look like that. Miss Wright told you this was taken in Miss Wright's house. The way Miss Wright always will remember Amari. Something happened. And it was likely an extension of all the things we've already seen and known. Maybe there was more beatings, maybe there was more blindfolding, more staring at the wall. Maybe it went too far. Maybe it hurt her body, because it was little. Couldn't take it anymore. The timeline, you will have all of this information with you. We've talked about it, you've heard the evidence, and you will have the information with you to go through. But what is very, very interesting, once again, is that in the search of this defendant's phone, all of these concerning searches that she did were deleted. Why? You don't want anybody to know that you're looking up how sewage drains work, or how to find missing people? You don't want anybody to know that you're about to rent a U-Haul? Why? On November 19th, around 4 in the morning, something likely happened, whether it was a being gone too far, that this defendant either directly committed, encouraged, participated in. Something happened. And that's why these searches on her phone, not Brittany Hall's phone, but her phone began. Interesting searches too. Are you trying to dispose of a body? The state will submit to you that that's what happened. Amari is likely now dead, killed at the hands of this defendant. Now they've got to get rid of him. She's got to get rid of him. So she's got to figure out, well, what can I do? I don't have a car. I don't have any friends. I don't have any family, according to her. What can I do? Well, I better figure something out. I'll go and search up some great idea. And the searches begin. So she has to delete them in case anybody ever finds them. Because they don't look good. Her movements are very telling. And again, you'll have the information. Detective Wilbanks did a fantastic job putting together all of her movements with the known information that we have. We know that on November 19th of 2021, this is why the state contends that Amari was killed on November 19th. Because at some point, early that morning before those searches started or around the time they started, and again, it doesn't matter what date it happened. We don't have to prove that, but the evidence shows that it's likely it happened on November 19th. Something happened, and Amari is dead, and the searches begin. And ultimately, the searches for U-Haul take her to the nearest U-Haul at around 1 o'clock. And you know from the surveillance video, where she is clearly seen, you know from the contract that she's put all her information on, you know from Detective Blackburn telling you that he sees the name of Celeste Owens on the caller ID of the U-Haul that she's calling, or someone's calling from that phone, obviously it's got to be her, it's her phone. And you know from the photographs that are taken when the van is returned later that day down on her phone, of her own driver's license, as well as the pictures of the U-Haul that is returned with the odometer, like you would do when you return a vehicle to make sure the tank is full and whatever you need to show. You see her leaving with the van that she has now rented around 1 o'clock in the afternoon, 1:13. And she stops at Family Dollar. And how interesting that what this defendant buys on video and through the receipt is bleach and latex gloves. You'll have the receipt with you. It says a pack of 4. CSI Johnson said they found 2 in the trash can at the hotel, double gloved. What happened to the other 2? Maybe in that backpack that the defendant is seen taking out of the U-Haul when she returns it that day, the black backpack, the same one the gun was found in at the hotel search. Leaves the Family Dollar around 1:40 on the 19th and heads back to the hometown studios around 1:55. Again, you'll have all this information with you. And then video shows her coming back, shows the van coming back. We submit that obviously it's the defendant. She's just left the Family Dollar. She's just rented the van and shows up at the hometown studios and stays there until 5:50 when it gets dark. Why does a person who lives at the extended stay hotel get out of the car and use rent a U-Haul for 6 hours? Because this defendant is transporting Amari's dead body out of the room. That's why. And coincidentally, right around that same time, as Detective Wilbanks testified, that's when the preferences on the iPhone change, where the location data is now turned off. So no one can track where she's going in a rented U-Haul for 6 hours on the day Amari is likely murdered. At 5:52, the video surveillance that you viewed with Detective Blackburn shows that the van is moved to a spot closer and backs in closer to room 251. At 5:52, around that time after backing in, the van leaves. I am now telling you the last moments of Amari leaving her home, her funeral procession, as she's being taken out to her final resting place at this event. That U-Haul leaves, and at 6:55, that Amari Hall. No location information, but the flashlight is activated on this defendant's phone. Because as you saw from CSI Jimenez, the area in which Amari's body was dumped was dark. So you might need to see where you're going. And at 6:58, there's a call to Brittany. Why? Could it be, hey Brittany, guess what? I just dumped Amari, we're good. Head back. I don't know, maybe. Interesting timing. Because then the U-Haul returns back to the A1 and then leaves again for a few minutes as Detective Blackburn defendant walking around and ultimately gets into the Uber and walks away. And all of these things on the side of the road, the flock images that you learned about and that you will have to see, those corroborate the movements of the van that has taken Amari away. The location data is turned off for 1 hour and 40 minutes. So much activity before that, as Investigator Wilbanks told you about, and then all of a sudden for 1 solid hour, she doesn't want to be found. But she has to have a phone, because how is she going to get an Uber back? And as soon as that Uber kicks in, that's when the location data comes back up. 27.2 miles. Detective Blackburn told you that's how far it is from U-Haul, Hometown Studios, to Amari's makeshift grave, and back to U-Haul. The mileage that the U-Haul contract that you will have will show is driven by this defendant. She was behind the wheel of that U-Haul. She's the one who dumped Amari's body. Took 2 people to kill her, took 2 people to cover it up, and 1 person to dump it. She's guilty of count 19, concealing the death of Amari, which hindered the officer's ability to figure out whether or not she was in love with him. Guilty by those actions of count 19. Zaire, who the only happy part about this story is watching her walk in. She lived to tell. She was Amari's voice as much as she could. She came into this room to look at 14 strangers and a whole bunch of other people in this courtroom to be questioned by one of the most experienced defense attorneys in this jurisdiction. And for the first time in 3 years, she saw this woman had to be 20 feet away from her for the first time. That's one pretty little girl. And what she tells you is that she ate bread. She tells you she looked at the wall, and you know she did. There were no toys, not in the search of the room, not when the officers got there, no books, no homeschooling. There's nothing going on. They were getting beat and staring at the wall and blindfolded when they weren't. Slept on the floor, no pillows. We saw it. And what she told you was that Amari was put into a container with a lid by this defendant, and put into the trunk of a car, taken to the hospital for bad kids. And that's corroborated by seeing the U-Haul. Why do you need to rent a U-Haul? They know they don't have a car, so I knew that. See, Amari's in a container being put in the back of a car in the trunk. That's corroborated by the fact that she had to rent a U-Haul to put Amari in the back to take her away. She says the man took Amari. Was that who she called Dad? It's a lot for her to come in here. So why did they even call the police? Because now they got to figure it out, right? They got to figure out what they're going to do. They have to call the police. They can't pretend Amari never existed because Papa and Gigi, Mrs. Wright, Mr. Wright, they weren't going to give up. They weren't going to stop looking for their grandchildren. They told you they drove around from place to place, from extended stay, from hotel, looking for their grandchildren. And they weren't going to stop. And they knew that. They knew the kids would probably ask about Amari. But they still waited 2 days so they could get their story straight until they called the police on the morning of the 21st. Because it gave them enough time for the search history around 3:43 on the 19th of how do I report someone missing and what to do when a loved one goes missing. They're trying to figure it out. They're trying to prepare. What am I going to tell the police? What do they want to know? And you can tell because in the interview with Detective Sorensen, when the defendants get real agitated there towards the end, because they keep asking her where Amari is, that's not what she was expecting. Based on her Google search I submit to you, she was expecting, and this is what she said to them, this is how you go about things. You get info bold-faced lie. She says, I didn't go anywhere November 19th. One of the many bold-faced lies, but she said, I didn't go anywhere November 19th of 2021, which we know is not true, based on all the movements we just talked about, based on the plot, based on the surveillance video, based on the geolocation data. There's so many lies. I take her toys away and talk to her. To Amari, this is what she tells the detective in her statement when she's disciplining her. It never got physical. She would not hit the children. These are the things that she's saying in her statement to the police. She doesn't know how the bruises got there when questioned about Zaire and Jakari's bruises there at the police department. Then eventually she says sometimes I gave her a licking talking about Zaire, but she classifies that as a pop on the hand. Then she says Zaire fell off the bed and she's a wild sleeper. Amari hits herself in the face. How interesting, since the only video we have is of her slapping Amari, hitting her in the face. Amari and Zaire would fight, and that's not true because Zaire came and told you they got along. She doesn't know where Amari is. You know that's not true. She starts talking about these strange people at the hometown studio, some crackhead and some lady with pimples on her face, and some guy walking around with a bin trying to pick up kids. It's lie after lie after lie, deception. And then she tells you she's with Diamond that night, the night before. My sister picked me up. I spent the night with my niece and nephew. Was there from midnight till 4 or 5 in the morning. Her own sister came in here and took the stand and said, no, that was a lie. She's guilty of making a false statement to Detective Sorensen by saying that she was with Diamond Owens at a time that was relevant in their investigation. That's count 21. She's guilty of that. And then all of a sudden there's a drastic shift in her demeanor, as you saw, ending with you're a piece of shit to Detective Sorensen. Based on the fact that now she realizes the gig's up. They're not just taking a statement like Google said they would and making a courtesy call. Now they're going to go through her phone. Now they've talked to her family. Now everything changes. She's not that worried about Amari through that entire conversation. She only gets emotional when she realizes the gig's about us. And the phone, first she's fine, because in her mind she's deleted all her history. She's deleted all the stuff that matters. Probably forgot about the videos that are still there. She knew she turned off her location information. And then when she realizes, okay, well, maybe they're not as dumb as I think they are, then all she wants is her phone back. I just want to get my phone and leave. I want to get my phone and leave. That's what she tells the detective in the interview. Mr. Greenwald talked about no DNA. I want to touch on both things. You heard that there was a search of the U-Haul for any kind of odor of the cadaver. And I want to make it very, very clear that there are some very logical reasons as to why the cadaver dog, whose first search it was, or second search it was, would not have hit on any kind of odor. And because we do believe Amari was carried in the back of that U-Haul van. And she told you, Ms. Schwartz told you, that the length of time in the back plays a big factor, that she would have only been in there less than an hour in the back, maybe in a container, but clearly in garbage bags, because that's where she was found, wrapped in garbage bags, and you can see in the crime scene photo that you'll have with you, there's a bag of Glad garbage bags, and they say leak-proof and neutralizes odor. We know she bought some bleach, maybe she cleaned it. She had the backpack. And the DNA? You're right, the DNA wasn't tested because there wasn't anything to show. The DNA would show who was in the room. We knew who was in the room. We knew it was all 4 of them. That's not going to tell us whether or not this defendant participated, helped, or directly committed blunt force injuries and lacerated liver to Amari. That's not this kind of case. So why? Why do this to these children? I don't know, maybe there were interference to the relationship. Maybe she doesn't know what to do with the kids. Maybe Amari was waiting to bed. She didn't really care about the impact that this type of behavior had on the other kids. This wasn't discipline, this wasn't anger, this was control. This was torture. These kids weren't doing anything. You saw in these videos, they're sitting there quietly, they're getting beat. Nothing that causes some or anything like this to happen to them. We don't need to prove motive, the judge will tell you. But there is no reason, which is what makes it so much worse. And this was intentional. I want to point out something that is very relevant. The reason that we put in the weight of this defendant and the weight of Brittany Hall is to show the discrepancy in size. Now, this defendant said she weighed 231 pounds at the time. You saw the video. Sergeant Campbell said that's based on the honor system. Even at its best case scenario, she really was only 231 pounds. Amari was 54. And Zaire and Jakari were likely less than that. That kind of force, that kind of weight on top of those children, and Amari was already weak, They had no friends. Those children sat there staring at the wall and having no idea that their Gigi and their Papa were out there looking for them. They had no idea the world was happening around them while they sat in that hellhole with her. We saw pictures on Zaire the night that the police brought them to headquarters. Look at her little extended belly. Her face. Remember Dr. Downs talking about the scars and the various different things on Amari? The scabs, various stages of healing. Same thing with Jakari. Those defensive wounds that Amari had on her arms. That's Jakari. His back, his hand, his extended belly. Randy Work said that in his experience with special victims, that's usually associated with not getting enough food. And this was purposeful. It was purposeful because she deprived them of food. There was plenty of food in that little hotel room. She was eating it. So was Brittany Hall. There was food everywhere in that hotel room, except for Amari, Jakari, and Zaire. Battered child syndrome, based on Dr. Down's testimony, indicates there were so many different, multiple fractures that were caused over a period of time, different places throughout the body, weakened her body, along with the fact Amari's body, without having any food, she weighed less than the 5th percentile, no muscle development. Again, doesn't matter who caused the fatal blow, doesn't matter the blood force injuries, we talked about those, we talked about the binding on the legs. The legs, Amari's legs were bound, in Dr. Downs' opinion. Her mouth, the injury that likely Dr. Downs sees with slapping Amari, wasn't one place in her body that was not hurt. She tried to defend herself, probably. That's what Dr. Downs said. Injuries on her little arms, because they were little. Amari could not come here and speak. Her body spoke. The internal injuries go on and on. 11 pages worth. You'll have that information with you too. What was significant is that significant injuries to Amari were likely caused within a couple hours of her death, which we contend happened on November 19th of 2021, the same day this defendant does her Google searches and deletions and rents the van and then dumps Amari's body. She helped, committed, encouraged. Her actions led to Amari's death. Her fractured ribs, the bruising to her lung. The first picture shows the bags that Kansas City technician Heather Johnson showed you that were found in that hotel room. You'll have those photographs with you, and you can see the diamond pattern on those bags. And ironically, when Amari is dumped in those bags, it's the same pattern. Because those bags came from this defendant, came from that room, November 19th, 2021. That's the bleach in the room. That's the latex glove. Crumpled up, doubled up inside the cup, next to the cigarette, which ironically this defendant, according to the receipt, did buy some cigarettes too, smoked cigarettes. And the worst part, all of this, is this. Dr. Down said that if they had cared enough to take Amari to get help, she would have survived. She would have survived. But they didn't care because she was trash to her. Amari was a vibrant little girl. That's what Miss White said. She knew her. She lived with her. She was her Gigi. Said she was respectful. She loved to dress up. She loved to cook. She let her crack an egg in the cornbread. Amari will always be 8 years old. This defendant took this Amari and did this to her. He took everything from her. She loved to dress up, so she left her naked. She loved her hair, so they cut it off. Zaire said Celeste cut it off. They didn't even put clothes on her. They didn't put her glasses on her. loved to cook, so they starved her. When I say they, that's she. When I say she, it's they. They did this together. It doesn't matter, but today's her day. She treated her like trash. But Amari Hall was anything but trash. She was a little girl. A little girl who didn't have anywhere else to go in her life. And she killed it. Ladies and gentlemen, the standards that we set for this community, the community that each of you have said you have chosen to live in, raise your children in, buy your homes in, work in. This community, the standards that are set in this community, what is acceptable and what is not acceptable in this community, it is not set by this honorable court or the district attorney's office or the Gwinnett County Police Department. It is set by all of you, each and every one of you, who in this moment in time will make one of the most important decisions that you will ever make within these hallowed halls of justice. Because today, the power shifts. This woman had the power over Amari for a long time, but today it shifts. It shifts here to you. The Gwinnett County Police Department knocked on every single door of the hometown studios looking for Amari. There is one door left, and that's this door, right here. That leads into courtroom 204, that leads to you. Today is that day. She no longer has the power. This defendant is guilty of every single count, and I ask you to find her guilty of all counts. Thank you.
All right, ladies and gentlemen of the jury, is everybody good? You need a restroom break? Okay, all right, we're gonna take a 10-minute recess. We'll come back for the charge of the court. All right, anything to take up outside the presence of the jury?
Not for the state judge.
Mr. Greenwell?
You let him know, Judge, that, I mean, I know everything goes back with him, but obviously there's no mechanism for playing stuff out. Just so that they know there's nothing for playing, any videos or anything.
Well, none of that goes back with them if they want to see any of that. So you want me to let them know that if they want to see a video or listen to anything again, they can ask?
Sure.
That's fine, Judge.
All right, try to remember that. The court has provided you with the final charge of the court. Any exceptions
No,
other than already noted for the record?
Is this the final?
This is the final.
no objection for the state judge.
All right, just take a 10-minute recess. Thank you.
Thank you, Judge.
Are we ready for the jury?
Yes, Judge.
Yes, sir.
All right, the foreperson. All right, sir, has the jury reached a verdict?
Yes, ma'am, Your Honor.
Was it unanimous?
Yes, ma'am.
Has the verdict form been filled in and signed and dated by you?
Yes, ma'am.
All right, Ms. Barnes? Celeste Alexandria Owens, indictment number 24B-03590-11. Verdict of the jury. We, the jury, find the defendant as follows. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, felony murder, guilty. Count 4, felony murder, guilty. Count 5, cruelty to children in the first degree, guilty. Count 6, aggravated battery, guilty. Count 7, aggravated assault, guilty. Count 8, cruelty to children in the first degree, guilty. Count 9, cruelty to children in the first degree, guilty. Count 10, cruelty to children in the first degree, guilty. Count 11, cruelty to children in the first degree, guilty. Count 12, cruelty to children in the first degree, guilty. Count 13, cruelty to children in the first degree, guilty. Count 14, cruelty to children in the first degree, guilty. Count 15, cruelty to children in the first degree, guilty. Count 16, cruelty to children in the first degree, guilty. Count 17, cruelty to children in the first degree, guilty. Count 18, cruelty to children in the first degree, guilty. Count 19, concealing the death of another, guilty. And count 21, making a false statement, guilty. Signed and dated this 13th day of December 2024 by the foreperson. You may be seated. Is the state ready to move for sentencing?
The state is ready, Your Honor. If I may have a moment to confirm with the family, I do believe they'd like to address the court at the appropriate time.
Before we do that, we request a poll.
All right, very good. All right, ladies and gentlemen of the jury, the defense's request a polling of the jury. What I'm going to have you do is starting with the foreperson, because I'm not sure what order you guys are standing in. So I'm just going to have you stand up one by one in the first row all the way down, and then we'll start with the second row, excluding the alternates, of course. All right, sir, you're juror number 17, is that correct?
Yes, ma'am.
All right. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you, sir. You can be seated. Can you tell me your juror number, please? 16. All right, juror number 16. Was that your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Thank you. What's your juror number, please? All right, juror number 2. Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you, sir.
18.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, ma'am.
Juror 19.
Juror 19, was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, sir.
Number 24, Your Honor.
Thank you, ma'am. Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
Thank you.
Number 25.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? Is it still your verdict?
Yes.
Thank you, ma'am.
Number 30.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you, ma'am.
Juror 36.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
And is it still your verdict?
Yes.
Thank you.
Juror 37.
Was that your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you.
Would you like one more?
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
And is it still your verdict?
Yes, ma'am.
Thank you.
45.
Was that your verdict in the jury room?
Yes, ma'am.
Was it freely and voluntarily made by you?
Yes, ma'am.
Is it still your verdict? All right, thank you. That concludes the polling. All right, ladies and gentlemen of the jury, at this time, I want to say thank you for your service, for your time and dedication over the last week. Obviously, this is not an easy case to sit, see, hear, and experience. And I know that I speak for both the state and the defense when I say thank you for your time.
Your Honor, the state does have some victim three individuals too, which will actually be speaking. May I go ahead and begin with the first individual?
You may.
Okay. Judge, I would ask Ms. Barbara Wright as well as Mr. Tony Wright to come up to the podium. They are the grandparents of Amari as well as Jakari and Zaire. And Mr. and Mrs. Wright, if you don't mind just stating and spelling your name, and then we can begin.
My name is Barbara Wright, B-A-R-B-A-R-A-R-I-G-H-T.
Mr. Wright,
Tony Wright, Tony-W-R-I-G-H-T.
thank you.
Judge, Your Honor, thank you for allowing me this time to speak. I want to thank the jury for their time. I want to thank the court for their time. I want to thank them for the verdict that they delivered this evening. Judge, Your Honor, this has been a great, big impact for me and my family and my siblings. My heart is broken in millions and millions of pieces that I have not been able to put back together. To know how my granddaughter passed away is words beyond. I can't imagine to find a word in the dictionary to describe my whole total feeling. But my heart is empty. I miss Amari every day. There's days I'm thinking that door's gonna open up and she's gonna come in. There are days that I fear her. I miss her so much. I'm trying so hard each and every day of my life to live forward without my Amari. Zaire, Jakari, her siblings, miss her dearly. Every day, Judge, Your Honor, I wake up. There's a picture that I have. I talk to Amari like she's still here. There's days where I feel like I can hear her voice calling me Gigi. Even when I go in the kitchen and cook and make that pan of bread that she thought was a cake, I feel like I can see her standing at the kitchen sink. I miss Amari. This impact of my life will never be put back together again. My granddaughter did not deserve the way that she was taken out of this world. Judge, Your Honor, no one deserved to be taken out of this world this way. I'm praying that God heals me. That He heals me in me and my broken pieces of heart. I will never get to see her play sports. I will never get to teach her how to drive. I would even never get to see her go to a prom. Do the things that grandmoms do with their granddaughters. All these things I'm going to miss with Amari. I'm sorry. would have knew Amari like I did. Those butterfly wings. And the laughter. And every time I close my eyes, Your Honor, I can see the pretty pearly white even teeth that she would have. The things that me and her used to share and say to each other. I can only hope in my lifespan, and I know I'm gonna go there one day, I get to see her and she can say those things to me again, that she meet me at heaven's door, because I know she's with the angels. She's beautiful. Thank you, Your Honor.
Thank you, Mr. Attorney.
Yes, I'd just like to thank everyone for doing a good job. And we really miss her so much. That's all I have to say.
Thank you, Mr. Wright.
Take care of, right?
Ma'am, if you would say and spell your name, please.
Takara Wright, Tacarawrighc.
Thank you.
First, I want to say, we got justice for my son. I thank you. I thank them. I thank them. And I thank you. If you knew Mari, sweetest kid you can ever meet. Sweet, loving child. My stepmother and my dad. I would never get to hear Gigi and Papa ever again. Not from her. My sister Sean and I would never get to hear the words TT from her ever again. Ever. Because someone just so senseless to do what they did to her and take her away from us. She didn't deserve that. I get it, nobody deserved that, but she definitely didn't deserve that. Sweetest kid. I've never ever seen my niece get angry. Now, did she kind of debate with my stepmom about fighting for the front seat? Gigi, I'm sitting with Papa in the front, of course. Happiest child ever. Loving kid. Light up your life. And for what they did to her. Respectfully, Judge, I hope she burns in hell. It was a baby. I can't imagine every day getting tortured like that. There's so many things I want to say, but I know I can't say them. So I'm going to pray to the Lord above, and I'm just going to end it by saying I thank you again, and I hope you don't give her freedom ever. She don't deserve it. Thank you.
Thank you, ma'am.
Your Honor, the state does have a recommendation, but before that, I did want to make a statement about some of the officers who were involved in this case. I think that this case has penetrated the souls of every human who has touched it, and I know with speaking with several of the officers who are also present here today and are watching, they also wanted me to relay to the court how they have been impacted by the things that they have seen and investigated, and I had assured them that I would. I think the evidence that the court has been able to hear and see is substantial in nature, and the state's recommendation is not made lightly. It is made taking into account what the victim had experienced based on the evidence and testimony that has come out. It is based solely on the charges that are present in the bill of indictment, a total of 20. The state is going to be asking for a sentence of life without the possibility of parole as far as count 1 malice murder is concerned. I think it is the only appropriate sentence given the circumstances of the death of Amari and the abuse of Zakaria and Zaire. The defendant does not have a previous criminal history, but given this case, the state would be adamantly asking for that sentence. Now, there are additional counts associated in the indictment that the jury has convicted the defendant of. I have conferred with Mr. Greenwald, and we both agree that the maximum sentence the court could give would be life without the possibility of parole plus an additional 235 years, and that would be the state's recommendation. I will be happy to break that down if that is what the court is inclined to give, but I think given everything that the court now is aware of, there is no recommendation that would be more appropriate than the maximum on every single charge. This defendant has been found guilty by this jury, so we would ask for life without the possibility of parole plus 235 years. Thank you.
Thank you, Mr. Zane. Mr. Greenwald?
Thank you, Judge. Your Honor, the way it breaks down, and I think we're in agreement on that, is count 7 would merge into count 4, count 6 would merge into count 3, count 5 would merge into count 2, and then counts 2, 3, and 4 would be vacated. So on count 1, the minimum sentence is life, of course. Maximum is life with or without parole. Counts 8 through count 18, the sentencing range is from 1 to 20 years. Count 19, the sentencing range is 1 to 10 years. And count 21, the sentencing range is from 1 to 5 years. And that's how we've got the life plus 235 years as the maximum. Ms. Nizam is correct, Judge. Ms. Owens has no previous criminal history. She was 29 years of age back in November of 2021. She's now 32 years of age, has been continuously in custody since November 21st of 2021. I'm the second attorney that's been on the case. She was declared indigent by the court. Prior counsel was appointed, and then I was appointed to replace prior counsel approximately 2 years ago, and have been working on her case since. I know Your Honor does not punish people for going to trial and exercising their right to go to trial. We respect the province of the jury and their verdict. They're certainly entitled to render what verdict they see fit. I would respectfully ask, and I don't know if Ms. Owens wants to say anything, but I would respectfully ask, in light of her lack of criminal history, that Your Honor impose a sentence of life with the possibility of parole, and counts 8 through 19 and count 21, whatever time you deem appropriate on those counts, that it be run concurrent with count 1.
All right, Ms. Owens, would you like to speak? Ms. Owens, please stand. Ms. Owens, I've been practicing law for a really long time. And I practice criminal defense, I practice civil law, and I've been on the bench, I've been a jurist for 25 years. This is by far the most heinous evil that I have ever seen in my entire career. And I do not understand it. As attorneys, jurists, we see really good people come in front of us based on their really worst days. But you didn't just have a bad day. The crimes and evil that was perpetrated against these 3 children is something that I will never understand, nor will I ever forget it. Based on that, the court does hereby sentence you as follows. Account 1, malice murder. You are hereby sentenced to life without the possibility of parole. Count 7 merges with count 3.
7 into 4.
I'm sorry, 7 into 4. Count 6 merges into count 3. And count 5 merges to count 2. Counts 2, 3, and 4 are vacated by operation of law. On the remaining counts, counts 8 through 18, and counts 19 and 21, the court does hereby sentence you to consecutive 235 years. So life without parole plus 235 years. You will never see the light of day to perpetrate this type of behavior, cruelty, and evilness upon another person. Go to the deputy.
Oh, I think we have to advise that on our appellate rights, ladies' rights.
You're correct, Mr. Greenwald. Thank you.
Thank you. So, Owens, you understand that if you wish to challenge this conviction, you may do so by what's called a habeas corpus petition, and there is a time limit in which you must file that petition, and that petition's time limit is going to be 4 years from today's date. Do you understand that particular time limit? Okay, and you also understand that there is an additional time limit of 30 days after your sentence is signed by this court in which you have to file a notice of appeal, and that would be 30 days. Or motion for new trial. That is correct as well. Thank you, Mr. Greenwald. Do you understand those time limits? That's all, Judge.
And Your Honor, what I would propose is that I'll file a skeleton motion for new trial within the next week or so to preserve her appellate rights, and then request that the court appoint appellate counsel since she's still indigent, so that we'll have someone from the appellate list start working on that.
I will do that Monday morning.
I'll file the motion for new trial Monday to at least stop the 30-day clock.
Yes, sir. Thank you.